All right, before I get into the due process of law notes, I wanted to go over something from the homework. Selective incorporation is the way that the Supreme Court has decided that it's going to apply the Bill of Rights to the states. Your homework said that, the Baltimore case said that the Bill of Rights only applies to laws passed by Congress and to federal actions, and that's still true. But what changed was after the Civil War, the 14th Amendment was passed, and it contained the equal protection and due process clauses, which prohibit states from limiting your access to your federal rights. So if it's a federal right, by all intents and purposes, it should then be a state right. But they didn't just do it as a blanket statement. They didn't just have one case and say the Bill of Rights now applies to the states and we're done. What they did was say that they were going to do it on a case-by-case basis. So a national protection, such as the freedom of speech or protection from self-incrimination, it exists in the Bill of Rights. A case comes before them from a state where it seems like something in the Bill of Rights is being deprived by state law. The 14th Amendment is applied to that case, and they take the item from the Bill of Rights and copy-paste it into the states, and now it's a protection that you have at the state level. So that's how selective incorporation works. So with that out of the way, let's go ahead and talk about due process. Due process is a phrase that gets thrown around a lot, and no one really knows what it means in all reality. Due process is a process, but it's not a specific process. It's a statement that there will be a process. So when something says you have the right to due process, it means that you are due a process. And the process is laid out through multiple amendments in the Constitution that explain how, when, and why the state can deprive you of your life, liberty, or property. There are two main types of due process. Substantive due process has to do with the courts protecting certain fundamental rights from government interference. There is the substance of them. They might not be specific rights that are mentioned directly in the Constitution or at all in the Constitution, but it's understood that they exist. The Ninth Amendment is there specifically for substantive due process because the Ninth Amendment says just because a right is not in the Constitution does not mean it is not a right you have. So something like the right to privacy, it's not in the Constitution directly, but it's alluded to. There are elements of privacy in other amendments and other parts of the Bill of Rights, and so substantively it exists, and you have a right to it. What we're going to mainly talk about today is procedural due process. Procedural due process are the procedures that must be followed by the government in order to fairly treat you the same as other citizens in depriving you of your life, liberty, or property because you have committed some action worthy of punishment. So the 4th, 5th, 6th, and 8th Amendments spend most of their verbiage on procedural due process. They literally explain the steps the government must go through if they are going to take away your rights. So we'll start with the 4th Amendment. The wording of the 4th Amendment is pretty straightforward. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall be issued but upon probable cause supported by an oath or affirmation and particularly describing the places to be searched and the persons or things to be seized. That is a pretty concise explanation of where you have privacy from government interference. Your physical person, your home, your papers and effects. So private documents, bank statements, records, your mail, those are all things that are protected. They are not to be searched unreasonably. They can be searched, but they have to have probable cause, which is, I'm going to explain here, more than just a hunch. And they have to specifically say what they're looking for, where they're looking for it, and why they're looking for it. So again, it's not an excuse to rummage through your life and find the things you may have done wrong. They already need to have clear suspicion with other existing evidence that you're doing something wrong. So let's talk about that probable cause phrase. Probable cause is the legal standard for a warrant to be given. A police officer, a government official can't just go to a judge and go, "Ugh, I really think that guy's up to something." That's not enough. That's a hunch. That doesn't get you anything. A warrant cannot be issued unless the judge has been clearly told what the crime is that they're suspected of, the evidence that's already been gathered, observations they've made so far, evidence in public view, and then the specific people, places, and items that they're looking for. That's probable cause. It's a high standard. That's why it's hard for judges to just give search warrants. That's why sometimes search warrants show up late and evidence isn't able to be collected, and sometimes, yeah, bad people get away with things. But it's in service of protecting your rights better, because if there was no probable cause and searches could be conducted at all times, then you would always be getting searched, and you would not have any place that you were secure from government interference. So the case that extended this right to the states was Mapp versus Ohio. Dottie Mapp was a Cleveland resident. She was a known bookie, gambler, all around notorious in the community for various petty crimes. The police showed up to her home to conduct a search. The search warrant was for records of gambling. She was acting as a bookie. They wanted to use her records not only to punish her for illegal gambling, but also to find the people who were coming to her to gamble illegally. And during that search, rather than find records of gambling, they found pornography. The pornography was illegal in Ohio at that time to possess. It was considered obscene materials. Talked about obscenity a little bit earlier. This was when states had broad authority to label things obscene. So she was arrested for possession of that pornography. Now, the search warrant they were given did not say anything about pornography, and it did not say anything about searching for obscene materials or possession of obscene materials. And so when it went to the Supreme Court actually sided with Mapp and said that the police acted outside of the scope of their warrant that they were given by a judge. And for a proper warrant, they would have had to go back to the judge and get the warrant amended. And so Mapp was released, and states now have that higher obligation that they need to follow when doing searches. You're probably hearing all of this and wondering why the police can stop people and search them in public. Well, Ohio actually helped with that one too. There's a case called Terry versus Ohio, and it led to what's called a Terry stop or a Terry pat. You're probably more familiar with it as a pat down, where a police officer searches somebody in public. They run their hands down the insides of the coats, they pat their legs, they pat their ankles, they pat their arms, all look, in a over the clothes, non-invasive search. The purpose of that search is usually to identify a weapon. The Terry versus Ohio case said that, in conducting their job, a police officer has a reasonable right to safety and the safety around the people being searched, and so they may conduct a stop to gain further information and also conduct an over-the-clothes pat-down for their safety. So reasonable suspicion is a slightly lower threshold, but it also allows for safe searches to be done, and then that further search would need to be done through a warrant. One of the most pressing modern issues within the Fourth Amendment has to do with surveillance. You probably haven't noticed too much of it because it's just been going on your entire life, but since 9/11, there has been a great deal of federal surveillance that has gone on in an effort to root out and break up terrorist networks. The primary piece of legislation that was passed to create this is the Patriot Act. And believe it or not, USA Patriot Act is an acronym that stands for Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism. It's unbelievable that they have somebody who comes up with all these acronyms for all these laws, but that's what it stands for. The goal of the Patriot Act was to expand policing powers for federal agencies so that they would better be able to intercept and disrupt terrorist attacks, but it truly ballooned into a massive domestic spying program. There were FISA courts which issued secret search warrants, allowing government agencies like the NSA to conduct mass surveillance, gathering tens of millions of emails, phone calls, text messages, location data from cell phones, GPS data, library records, and information from your internet service provider, all without your knowledge. We only came to know of the scope of this program when it was leaked by Edward Snowden, who publicly released the information. He was a contractor that was hired by the NSA to do computer work, and discovered just how massive the program was, and he was so disturbed by it he thought he needed to act as a whistleblower and leak that information to the public, and has since had to flee the country because of it. The Fifth Amendment is most of your due process rights when interacting directly with the legal system. Specifically, it says no person shall be held to answer for a capital or otherwise infamous crime unless a presentment of an indictment of a grand jury, except in cases arising in naval or land forces or in the militia, which in actual service in time of war or public danger. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any case to be a witness against himself, nor to be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. There's a lot in there. It's quite the run-on sentence. So I'm going to break these parts down discreetly and talk about them independently. So let's start with the grand jury. A grand jury is different from a petit jury. The petit jury is the 12 angry men in the room who yell about the knife. It's a really good movie. That's not what a grand jury does. A grand jury is before anyone is put on trial. It's about 20 people usually. The defendant is not there, only the prosecutor is there, and the prosecutor presents all the information and evidence that they have gathered against the person that they wish to charge, and the grand jury's job is to decide if that evidence is actually sufficient to charge you with a crime. So it's a good tool for prosecutors because they can actually test charges against a grand jury, and see if the evidence actually meets what they're trying to charge the person with. And sometimes the grand jury will actually hand down a lower charge and say, well, the evidence that you have is not sufficient for the crime that you're trying to charge this person with. This hasn't been incorporated at all states for all crimes. Most states have rules about grand jury indictment for capital crimes, murder, capital fraud, arson, things like that, but it's not the same in every state. It's not uniform across all the states, and that's why it's only a partially incorporated amendment. Double jeopardy, which sounds very exciting because it means double points usually. Unfortunately, double jeopardy is actually a little bit more mundane. It just means you can't be put on trial twice for the same crime. No, that does not mean you should immediately go out, commit a crime, get punished for it, and then you get infinite chances to commit that crime the rest of your life. It means the same instance of a crime. So you cannot be put on trial and the jury finds you not guilty, and the prosecutor's so mad because he just knew you were guilty. You looked so guilty, so he calls a new jury and they put you on trial again. And they just keep doing that until they get a jury that will convict you. That's what double jeopardy protects against. The state only gets one chance to find you guilty, and if they don't get you found guilty during that chance, it's over. You're free. The state cannot use its infinite resources to try to get you found guilty. It doesn't mean that you can't be tried from the same instance by multiple jurisdictions. So if you break a law, in committing that action you broke both federal and state laws, well, you will have a federal and a state trial, and you will be punished by the federal government and the state government. So double jeopardy does not prevent you from being charged by multiple jurisdictions. It just means that each jurisdiction only gets to try to charge you once. So those would not be violations of double jeopardy. Your protections against self-incrimination mean that you don't have to be a witness against yourself. There is no situation in which a police officer can compel you to confess to a crime. They will try. The police are under no obligation to protect your individual rights in an interrogation. It is on you to protect your individual rights. They can even lie to you and tell you that other people have confessed that you did something to try to get you to panic and maybe give them more information that would be helpful. That is them doing the job that they have to do. you do not have an obligation to provide any evidence against yourself in a form of confession. When the police arrest you and they tell you you have the right to remain silent, it is absolutely information that you should value and listen to. The only person who should be talking is an adult or your lawyer. It should not be you. Eminent domain is that last part of the Fifth Amendment about just compensation for land being taken for public use. Eminent domain is the government's ability to take property from you if they're going to use it for a public use. Now, the most common uses of eminent domain used to be things like they wanted to build a highway and it went through your farm, so they paid you the cost of the land that the highway was going to use and maybe compensated you in other ways, like built an overpass so that you could take your tractor underneath the highway to get to the other half of your property, things like that. Running water lines through a neighborhood is a pretty common use of eminent domain. There are public egresses, is what they call them, where the city or the state has access to your property to do maintenance on things like utility lines, power lines, water lines. Even the president's plan to build a border wall requires heavily that the government use lots of eminent domain because the border is not actually public territory, it's private territory. There's thousands and thousands of landowners all along the southern border of the United States who would have to sell their land to the government by force in order for the wall to be built. And eminent domain would have to pay each and every one of them for the use of their land. Probably the most controversial element of eminent domain in the modern context is for what's called public good eminent domain cases. And that's where a city might use eminent domain to take your property because, well, you were just a homeowner and you were only paying some taxes on that land, but Walmart would love to build a Walmart there, and then they'd have a bunch of employees who would pay taxes, and there'd be a bunch of sales taxes generated by it, and so it's actually in the city's best interest to take your home and pay you the minimum value they could for it, and then give that land to a private company who would then generate much more revenue for the city. It has been done. It is legal. The Supreme Court has upheld that kind of use for eminent domain, but it is very controversial because it does seem to be exploitive of individual landowners on behalf of larger corporations. Probably the most important Fifth Amendment case in U.S. history was Miranda versus Arizona. Ernesto Miranda was not a nice guy. He was violent, he was a criminal, and he was arrested for perpetrating violent crime. When he was arrested, he gave a confession to the police, but later argued that that was coerced out of him and that he didn't know he didn't have to cooperate with the police and give them a confession. And so when his case went to the Supreme Court accepted the argument that he was unaware of his rights and the police did not help him become aware of his rights. And so if you have ever heard the saying that the police give to you when they arrest you, that you have the right to remain silent and anything you say can and will be used against you in a court of law, you have the right to an attorney. If you cannot afford an attorney, do you understand these rights as they have been spoken to you? That is called the Miranda rights because they come from Miranda versus Arizona. And that is the police informing you of your rights before you have a chance to say anything that might be incriminating. Because if they have informed you of your rights, then anything you say can and will be used against you, and that will be just A-okay with the courts going forward. So that is why the Miranda rights are read to every person. They've even verbed it. You are Mirandized if they have read that statement to you. The Sixth Amendment has to deal with mostly your rights during a trial and how that trial is to be conducted. It says that your trial must be speedy and public. The courts have not actually put a timeline on what speedy looks like. I've asked a county judge, and he said typically 90 days from when you are charged with a crime. Within 90 days, they should have you in a courtroom, is at least at the local level, the timeline that they try to act on, but it could be longer than that. You have the right to an impartial jury. Impartiality is challenging. People have internal biases, but the juries do tend to be screened for at least overt biases against the person who is on trial. You can't control what people think and do inside themselves, but you can at least weed out some of the more overtly objectionable jurors. You have the right to be informed of the nature and cause of the accusation, so you have to be told what you are charged with. That is habeas corpus, so it's reaffirmed within the Sixth Amendment. You have the right to confront witnesses against you, so if someone is going to be a witness against you, it cannot be an anonymous witness. You have to have the ability to confront them and challenge the accusations that they are making, and you have to have the ability to call witnesses who are there to speak in your favor. And lastly, you have the right to have counsel assist you. Counsel in this case means a lawyer who will help defend you. Some parts of the Sixth Amendment have not been incorporated to the states, so it is another one of those partially incorporated cases. The most important Sixth Amendment case, though, is Gideon versus Wainwright. Clarence Gideon was a small-time crook. He robbed convenience stores, sometimes claiming he had a gun, sometimes with a gun that was unloaded. Not exactly violent, but definitely intimidating. And he was arrested and put on trial in the state of Florida and was forced to defend himself at his trial. He was not presented with a lawyer. And so from prison, he began a letter writing campaign to get his case heard by the Supreme Court, and it actually worked. Gideon's case was taken what's called in forma pauperis. It's more Latin. It just means in the form of a pauper. So someone who is poor and does not have a lawyer advocating for them, the courts will give them a lawyer to help them strengthen their arguments if they think there's a case to be heard. And so that's what the Supreme Court did. And what they ruled in Gideon versus Wainwright is that yes, states do have an obligation to supply you with a lawyer if you cannot afford one. You have the choice to not have a lawyer, but it must be your choice, not the state's choice. If you want to represent yourself, you're a fool for your client, but it's your option. You can choose to represent yourself. The state has to offer you a lawyer still. There's not a lot to talk about with the Seventh Amendment as it is not incorporated and therefore only applies to the federal law, but it does contain one peculiar element. As you can see, it says, in suits at common law where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved. The Seventh Amendment is all about civil lawsuits. It's about being sued or suing other people. And the most bizarre thing in here is they included the term $20, which means that in 1789, when they put the Seventh Amendment in the Bill of Rights, they included an actual monetary amount as the threshold. So today, that is still the amount for a federal lawsuit. If you want to know why the United States is such a litigious society in which people can sue and do sue for many, many, many reasons, look no further than the Seventh Amendment saying that the monetary threshold, the value in dollars that must be damaged before you can have a jury trial at your lawsuit, is $20. If you made somebody an hour late to work and they made $20 an hour, they could have a jury present at the lawsuit where they got you to pay them $20 back. It's one of the main reasons why you usually don't put hard dollar amounts in your long-standing governmental documents. You leave that up to the legislators to decide. The last amendment we're going to talk about today is the Eighth Amendment, which again is nice and brief. Excessive bail shall not be required, nor fines imposed, nor cruel and unusual punishments inflicted. So there's it's technically three cases, but two groupings of cases we're going to talk about. The first one has to do with the fines and bail. That's a recent one. That's Timbs versus Indiana. And I know this looks like some guy's album cover that he would post on his SoundCloud account. But this is Mr. Timbs. He was a heroin addict in Indiana, and he sold $400 worth of heroin and was arrested for it. He sold it to an undercover cop. And so he was sentenced to, I believe, 1 year in prison and drug therapy. He completed both of those. In the process, though, the police confiscated his vehicle, which was a $45,000 Land Rover. The Land Rover, they claimed, was part of his drug issue. And so they confiscated it and sold it at auction. In Indiana, the maximum fine for the amount of heroin that Mr. Timms had sold was $1,000. So that means that the vehicle was, 45 times more valuable than the maximum fine allowed by Indiana law. So Timms sued the state of Indiana, took it all the way to the Supreme Court, and the Supreme Court did selectively incorporate the Eighth Amendment in total to all of the states, saying that, if the maximum legal penalty for the crime was $1,000, selling his vehicle, which was a $45,000 vehicle, certainly would exceed that and be an excessive fine. So they were forced to pay him damages for the vehicle, all of his legal fees, and now he gets to be in history textbooks. So it's a big win for Timms. The last major case is actually a pair of cases, both dealing with the death penalty. The first was Furman versus Georgia, and that was the case that actually briefly suspended the death penalty in the United States. Now, the main reason it suspended the death penalty was because of the inaccuracy and frivolity of the sentencing. In a series of cases that came before the Supreme Court, what they found was that judges were being capricious in their use of the death penalty. They were giving it out in cases that had identical circumstances. One defendant would get the death penalty, the other defendant would not get the death penalty, and it would be the same judge handing down the sentences. And so the judges were being very indiscriminate with their use of the death penalty, and what they found in the case was typically the defendant who was sentenced to death would be a black defendant, and the defendants that were sentenced to life in prison would be white defendants. And so there was a heavy racial bias in the use of the death penalty in those cases that were ruled on in the Furman case. So that put a pause on the death penalty almost nationwide. The federal government ceased all of their executions. Virtually every death penalty in every single state after the Furman ruling was commuted to a life in prison sentence, and the death penalty ceased to exist in the United States briefly. Gregg versus Georgia, though, did bring it back. What happened was states went and looked at the Furman rulings and adjusted their laws to compensate. So if the courts said that they were being indiscriminate with how they handed down the death penalty, they could change how they handed down the death penalty. And what most of the states settled on was taking the use of the death penalty away from judges specifically. The judges could reduce a sentence from the death penalty, but they could not increase a sentence to the death penalty. They left the death penalty in the hand of juries, and it was the jury's job to hand down the death penalty. And so the courts felt that that was a less discriminatory way. It may not be perfect, but it served enough to let the courts allow for death penalty convictions to go forward. So, all of these cases, all of these amendments have to do with due process. And the important thing to remember about due process is these are the rules the government has to follow to take away your rights. If they don't follow these rules, then they are a tyrannical government. The burden is on the state to prove that you have committed a violation and it is deserving of punishment. And if they cannot prove that, then your life, your liberty, and your property must remain intact. It is one of the principal rules of limited government that the policies and procedures that are enacted to strip people of their rights must be followed exactly every single time. And you may hear arguments that might allow for people who have done wrong to go free, and that is absolutely true. It could totally happen, but it's much better to live in a world where the side of the law is always giving the citizen the benefit of the doubt, because the citizen has much less in terms of resources to defend themselves than the state does. And so we should always err on the side of caution and err on the side of the citizen over the state.